All right, so maybe we start with choosing an executor. We talked a bit about it last time and how they will be responsible for divvying up all of your things and kind of
Hmm.
handling everything.
Yeah.
How do you choose one? What's a good person? All of that.
The role of the executor is to find all of your assets, right? Collect all of the money, the items, the things, identify where they are, and then distribute them to your beneficiaries. They have to find all of your debts and pay those. But they also don't have to do everything themselves. They can hire an accountant, they can hire a financial advisor, they can hire an attorney. So they can hire experts to help them, and often that's really helpful, um,
Hmm.
because it can be really overwhelming, especially if they've never dealt with an estate before. To have people who kind of know what they're doing, to give some feedback and to help along the way can be really beneficial. So really, when you're thinking about who you want to appoint as your executor, you want to think about the people in your life that you trust. Often, right, if you're married or you have a partner, often your partner will be the first person that you choose, because chances are most of what you own is owned jointly with them. So it's just simpler. Then people tend to look at, if they have children, looking at their children, maybe their siblings. Just because you have an adult child doesn't necessarily make them the right person for the job. Often they are, but they might not be. So, what you want to think about is, are they capable of doing the job? And are they willing to do the job? Right. For example, my brother, when I was doing my advanced healthcare directive, he was very clear. He doesn't want it, even if two doctors have said that I cannot be resuscitated, that I have no quality of life. He doesn't want to be a part of that decision. He's not emotionally capable of being a part of that conversation, and explicitly
Hmm.
asked to be left off the document. You might have people in your family that just don't want, or in your life that don't want to do the job. So if they don't want to do the job, don't appoint them, because they don't have to do it just because you've put them in the document. So it's important to kind of maybe start having those conversations. What would the job entail, as far as what is actually in your estate? What is the work going to look like? Who are you leaving your things to? What is their relationship to those people? Like, for example, maybe you don't have a great relationship with or all of your siblings don't have great relationships with one another, and you're leaving everything to your siblings. Maybe appointing one of them as executor is not going to be ideal, because it's just going to create more conflict. So just trying to keep in mind, what are the dynamics of the relationships, and are they capable or willing to do the job?
Hmm.
So, really thinking about what makes somebody a good executor. One, do they have time? Somebody with, maybe that's an attorney that is working, the 60-hour work weeks. This might not be a great job for them. They might be fully capable, but they don't necessarily have the time to devote. Um, and that can be frustrating for them and for the beneficiaries, because it can just make things kind of drag out. Maybe they're not very good with money. Maybe
Hmm.
they've never, right, they get a penny and they spend it kind of a person. That's probably not an ideal person, just because the temptation of having a pile of other people's money in front of them might not be right. For some people, that's very tempting. I, a lot of people think, let me do my spouse, my eldest child, and then go down in age order. If Don't do that just because you think that's the right thing to do. If they're not suited to the job, if they don't want to do the job, if they don't have time to do the job, don't name them. They might have their feelings hurt, but really the key is who's going to be able to do the job, well and efficiently, and identify when they need help completing the tasks.
I talked with a death doula last week and I had her kind of explain choosing your medical power of attorney.
Hmm.
And that can be the same person as your executor, but also could be different people. And sometimes I think with the kid example, you might have a kid who is really able and willing to do the medical decisions, but doesn't really want to deal with the financial side of things, and then another one,
A
vice
hundred
versa.
percent.
So,
Yeah.
yeah, I think keeping in mind that you don't have to always choose just one person, it could be multiple people for different things.
Exactly. And often, right, people have very different strengths. So just keeping that in mind, and you shouldn't worry about hurting their feelings about whether or not they've been chosen. It's not about, it should not be about pleasing people. It should be about finding a person who can do the job.
Hmm. Um, do you recommend that people choose a backup executor in case?
Yes. Yeah,
Okay.
we typically recommend that people name three different people.
Okay.
The third person is just in case. You don't normally need to get to the third person, but you very often have to get to the second person. Either because somebody has predeceased, or maybe they're no longer competent, right? Maybe they have dementia or something, just because of age, they're no longer capable of doing the job. So often you get to the second person. The third person is just, right, you're there spending the money and the time doing the documents. Think about who another backup could be. Um, it does come up, and sometimes we've had situations where all three of those people are no longer capable, and then a court has to appoint someone. So
Hmm.
like we sometimes call it, like, you want the belt and the suspenders. You just want to make sure that you're fully thinking through the options of who would be um, appropriate and capable while you're sitting there doing the document anyway.
Yeah, I like that analogy. All right, one final follow up to that. If you
Yeah.
change your mind, I mean, I'm guessing you can just go in and, like, let's say you put your husband, but then you get divorced. You can go in and
Mhm.
change that.
You can go, yeah, yeah, if you change your mind, yes, you can go change your will. If you get divorced, at least in New Jersey, that your ex-spouse is automatically out.
Oh,
Um,
okay.
so like kind of we talked about last week, anytime you have a major life change is a time to revisit your documents and think of, like, a divorce is a perfect example. Your now ex-spouse is no longer, they're automatically removed as from your will as or your power of attorney from any kind of fiduciary role, like executor or power of attorney, and they're also removed as a beneficiary. They are not, however, necessarily removed from things like an IRA,
Mm-hmm.
any kind of bank account or something where you name a beneficiary, it's where it automatically goes to them on your death. They won't necessarily be automatically removed from that. So,
Okay.
um, just something to keep in mind. And a good divorce attorney will make sure that you really go through that as you're getting divorced, but just a good thing to keep in mind.
So, okay, that's interesting. So, if I'm married and then I have my husband as all of my things on my will, and then I get
Hmm.
divorced, and I don't
Hmm.
touch my will,
Hmm.
and then I die, he's
Hmm.
just automatically out because we've been
Yeah.
divorced.
Yes.
That's
So
good.
then, if you have alternate beneficiaries or an alternate executor, it automatically would go to them. If not, then it would follow whatever the intestacy law is of where you live. So, like for an example, in New Jersey, it goes first to your spouse, and then your children, grandchildren, etc. If there's nobody in that line, then it goes up to your parents. Um, and then your siblings and their children. If all of them, if they're either predeceased or you never had them, then it goes up to your grandparents, and then uncles, aunts, cousins. So there's a
Oh,
very clear way of determining who the beneficiaries would be. But this is why we always recommend um, having a primary beneficiary and then an alternate. If for some reason um, they've predeceased, or something happens, or they decline, right? Some people say, I don't want this money, maybe for tax reasons, often more for Medicaid planning. They don't want to get it the inheritance because it could impact the kind of care that they're
mm,
entitled to receive.
mhm.
um, have an alternate. So, like, what most people do, everything goes to their spouse. If not to their spouse, to their children. If not their children, their grandchildren, right? That
Mhm.
would be like a typical scheme, but that could look, depending on what your family looks like, or your loved ones, it would be different. um But so just like you would do that with your bequest for all of your stuff, you want to do the same thing with your executor.
Okay. And let's say in the divorce scenario, you have kids with your ex-husband and you still want, if you were to die, you want him to receive your money. You can put that in your will
You can do
as
that,
long
but
as you
the will
update.
has to exactly. The will has to be
Okay.
dated after the date of your divorce.
Okay.
So, yeah, if you still want your ex-spouse to be appointed, which does happen sometimes, right? Because it's very amicable. Maybe they're the parent of your children. Maybe they just know a lot about all of your stuff and you're going to continue to sort of consult with each other about um, your assets or other decisions in your lives. They can still be in the document, but it has to be dated after the date of your divorce. If it's dated
Fascinating.
prior to the date of divorce, or I believe in some places even the date of the divorce, it won't be valid. It has to be after the date of the divorce.
Wow. I'm learning a lot. So basically, my understanding is if you have kids, you should be choosing who will take your kids if you and your partner, if you have a partner, die.
Yes.
Um, what else?
So, yes, it's really important for you to think about who you want to name um, as a legal guardian of your children. And there are two pieces to this. In my opinion, you want to name a guardian for the child, like the person, and then a quote unquote guardian for the money, right?
Okay.
And they should not be the same person. Um, why this is really important is because if something were to happen to you and the your children's other parent, if they have another parent, then the court gets to decide who is going to be their legal guardian. And that could be a family member. It could be somebody totally unrelated, but you will have no control over who that person is. If you put it in your will, that's the person. Unless there's something really, crazy and untoward that's happened, that's going to be respected over any other factors. So when you're thinking about guardians, kind of similar to the executor or like any of these roles, you want to think about who is the best person for that job, right? A lot of people often say, well, if I'm going to be gone, I want it to be my mom, for
Hmm.
example. But just think about just because maybe your mom is very involved in their life, uh, she still may not be the right person. I'll just use my family, for example. My daughter is 3, and my father is 67. Okay. He's very involved in her life. They have a wonderful relationship. He would take very good care of her. But he's 67 and she's
Hmm.
only 3. If something were to happen to me and my husband tomorrow, the chances of a secondary guardian needing to be appointed to take care of Daisy are very high.
Hmm.
And so just thinking about, and maybe you're okay with that, but that's a lot of change for a child that's already lost parents. So just
Hmm.
thinking about keeping in mind the age when you're making that choice. It may not change your mind, but it's just a factor to consider. The other thing that we really recommend is that you never name like two people together. Like, so maybe like for example, my cousin and his wife are the people that we have chosen as the guardian, potential guardian for my daughter. They might get divorced.
Hmm.
And that creates or could create a really big problem for your child. And then who is responsible for the care? How is that going to be managed with these people who are no longer living together? Right now you've got to deal with the dynamics of this couple separating, but like what does that legally mean for your child and how is that going to be dealt with? So instead of naming them together, you pick one and name them first and pick this other one and name them second.
Okay.
Um, Hopefully they won't ever get divorced or separated, but this is just a way to avoid that problem. Again, we'd like to name at least 3 people. If maybe what you have is like 2 couples in mind that you think would be good, you could name all 4 of them just one at a time and pick the couple that you elect first, name the 2 of them first, and then the other 2. You also want to name trustees, and those would be the people responsible for the money. And those should
Hmm.
be, if possible, those should be different people. hopefully the people you've chosen to be the guardians of your child or children are totally responsible, um, upstanding people and will not spend the money that you've left for your child on themselves or, in ways that you would not want. But having a a trustee to be responsible, again, it's like the belt and suspenders. You've just built in another person to kind of keep some checks and balances on how the money is being spent. Is it actually being spent on the child and their care? Um, or is it being spent on the guardians, like, I don't know, wardrobe or fancy vacations or something?
Mm-hmm.
um and again, with that, one person at a time, and think about who is who can be responsible for that money. Again, they can hire a financial advisor, to help them manage the money, and you can dictate in your will, kind of what the terms of that trust would be, how what they can spend the money on. So you get to decide how much discretion they have with how the money can be spent.
Okay.
Usually the direction is going to be for, health, welfare, education, school, their clothes, doctor's appointments. You could be giving money for food, housing, whatever it might be. But the discretion, you get to decide as the parent, right, in this document, how much discretion that trustee gets to have. Do they get to decide fully how it gets spent, or are you going to give them parameters on how you want it to be spent? And then part of that also is, at what point does that money that's left for your child or children in trust become theirs solely to spend?
Mm-hmm.
Um, Often we recommend that you don't give it all to them when they turn 18. What we often will do is do it in, like 3 or 4 chunks. So maybe they'll get, a little bit 18 at 18, or maybe, you wait until they're 21, and sort of space it out and give the final balance when they turn 30. Usually somewhere between 25 and 30 is what people, recommend, just because, right, most 21-year-olds are not going to be super responsible with money.
Mm-hmm.
um, Not all 21-year-olds, but a lot, right? They're going to be more focused on vacation, drinks, dinner, whatever, like fun things, right? And not
Yeah.
thinking about, could this money help me buy a house or go to graduate school or whatever else?
Yeah, for sure. Um, and as far as pets, I
Mhm.
my understanding is they are not considered people, they are property, and you can give all your money to them, but it would need to be put into a trust, similar to what you were saying with the
It
kids.
would need, yes, it would need to be put into a trust. Um, and usually whoever you're naming as the guardian, quote unquote, for your pet is who would be the trustee. Um, a lot more people will deal with this outside of their estate.
Okay.
If I mean, I think for most people, or at least I could speak for myself, um, I don't need to worry about my dog. There are literally at least 15 people who are going to fight over taking care of him. But if you're really worried about it, you should identify those people during your life. Make sure they're willing to take your pet or pets. Um, and some people will, right, they'll work that out during their life and then maybe set up a bank account, um, that they'll fund that's POD to that person, and that's the money to care for the dog. That would be the less expensive route to take. Or you could create a trust. What you decide to do may just depend on what other decisions you're trying to make, about your estate, how complicated it is. And that would be a good conversation to have with an attorney.
Okay. So we've kind of gone over at a high level all of the things you need to think about, figure out, and plan in order to create your will. Um, I think most people have a pretty good understanding that in order to do that, you need to sit down with an estate attorney and pay them and do things like that.
Mhm.
There are options online. So I wanted to get your thoughts on, is that worth it? Is it okay for people to do that? Maybe they can't afford an attorney. would you say don't even think about it? Just don't. It's better to not have something than to do it for free online. Like, what are your thoughts on that?
So there are a couple of problems with doing it online. One is that there is no context given when they go through the questions of how to fill out the document. So, like for example, there's a residuary of an estate. That's all of this stuff after you've dealt with specific bequests. So a lot of times it'll take you first through the specific request. So I want, John to get $20,000, or I want Sally to get my car. And then there's the residuary. That's everything else in your estate. And they
Mm,
don't give you any sort of context for what that means. And so for an example, we had a client who used, like, they found a form online and printed it out and hand wrote in all the information, and they left the residuary blank. And the result of that, we think what she wanted was for everything to go to her friend's son. That's who she left everything else to, but she left it blank. So legally it went to her next of kin, which were her cousins. And that was a significant amount of the estate. And that's, I could say with a great deal of confidence that's not what she wanted, but there was no evidence to support, right? There are no notes that she wrote down at the time, right? She didn't talk to an attorney, so an attorney didn't have the conversation and make a mistake. So there was nothing to take to a judge to say, I think this was a mistake. This isn't what she wanted. Um, if you had evidence, right, you could go to the judge and they could reform the will, which is they could make a change. Now, that's expensive, that takes time, but it could be done. So that's one of the problems with online documents is they don't ask you any of these follow-up questions. And then also there's no evidence of what your intent was. And your
mm-hmm,
intent is really important as far as enforcing the document, legally speaking. Um, so it may not actually do what you want it to do. And there would be no way for you to know that unless you've had an attorney look at it.
mm-hmm,
So that's one. The second is that if you make a mistake, like I have another client who was helping his sister do all of her documents online. She used LegalZoom, paid a lot of money. I think for the will they did, it was like $500.
mm,
And they spelled one of the beneficiaries' names wrong, and LegalZoom will not allow you to correct that. So in order to correct it, you have to pay for an entirely new document.
mm,
Um, so there's just it sometimes is less expensive. Um, but from at least what I have seen anecdotally, it's not that much less expensive than going to an attorney. Um, right? Like we would probably charge $800 for a will, and that's for all of the time, right? Every single conversation, all of the edits to the document. If for some reason we made a mistake in the spelling of somebody's name, you would come back and we would reprint it at no charge, right? That's the
mm-hmm,
benefit of spending a little bit more money versus on LegalZoom, you've paid $500, you've made an error and you can't correct it. So now you've got to spend another $500 to redo it and make sure that it's okay.
mm-hmm,
Um, Something that I should raise now, just thinking about it. Do not, if you make a mistake like that, do not go in your will and cross something out and write something else in. In
okay,
most places, that will not that will not be accepted by a court, and the result of that will be that that person gets nothing, or you've got to go to court and argue about it. You should not do that.
okay. Good to know. Um, that you brought up how much your offices charge for estate planning. I was going to ask a question around that just to give people a general idea of what they should be expecting ballpark. I think
Yeah,
sometimes people feel like, oh, I'm going to go to an attorney and just be charged for all these hours and it's going to rack up this
yeah.
huge bill. I'm guessing that's not always the case, probably not often the case. But what would you say for people is like a keep this in mind? And does it vary depending on where you live?
It definitely is going to vary depending on where you live. One thing to keep in mind is that, right, pursuant to the rules of professional conduct, attorneys have to charge a reasonable fee. And that is based on whatever is common in your area. So, like what's common in New Jersey is not necessarily going to be the same in like New York City or in California, Wyoming, where it's all going to be different depending on where you live and
Okay.
what's standard. So that's something, right? You could call a few different attorneys in your area to just get a sense of prices.
Hmm.
At least here, for wills, um, general durable power of attorneys, your advanced healthcare directives, they're fixed fees. It's not an hourly, it's just one fee. Um, so that would include, again, all of the conversations you have about like what you want to do, what makes sense, all of the drafts, and then actually executing the documents in person. That may not be common everywhere. Some places may charge by the hour. I think generally speaking, there will be more variation as far as trusts go,
Okay.
depending on how complicated they are. Um, that can have a much greater scale. But from what I've seen, I would say you could expect anywhere between maybe like $400 and $1,200 for a will,
Okay.
all depending on where you live, right? I think if you live in a big city, expect something closer to the top end of the range. And it might be less, right? I don't know what everybody charges, but I think that's probably a good range to kind of have in the back of your mind when you go into those conversations. And if you talk to an attorney and the fee seems high, just maybe call a couple other attorneys in the area and just see if it's comparable. Um, because there are going to be attorneys who will charge you a lot of money. Um, and they'll try and justify that by producing like a 40-page will. Nobody needs a 40-page will. It might be like a 10 or 15-page will, depending on, right? If you have like 20 relatives you want to leave things to, that's going to naturally make it a longer document. But there's nothing that's going to go into your will that would dictate it needing to be that long. There are a lot of attorneys who will try and take advantage, and they'll give you like a fancy binder with all your documents. You don't need all of that. Um, so just make a couple of calls to make sure you feel comfortable with the person that you're hiring.
Okay. That's some good advice. Let's say I have come to you, I've done my estate planning with you, maybe I have a trust as well,
Mhm.
and then I die, and my brother is my executor.
Mhm.
When should he be reaching out? How does he know? Like, what happens after I die, I guess?
So, in New Jersey, you have to wait, I believe it's 9 days to be appointed executor. So there's no rush to do anything immediately.
Okay.
Um, but you should start like looking for the will, because sometimes that takes a little while to find, for depending on where somebody has put it. But start to try and collect documents. Um, that's why it's really helpful to tell your executor, whoever you've appointed during your life, that you've appointed them. Tell them where your important documents are. Um, I think we talked last time about how we have in our office like a will questionnaire that we kind of use as like a should be like a living document that you update from time to time with where your different bank accounts are, maybe what the debts are. Like there's a lot of information in there. We usually recommend that you keep that with the will, or let your executor know where it is. Same with that personal property document, so that they're not scrambling to try and find stuff. Um, so first is for them to just find the documents and figure out, what it is that you wanted. Um, Depending on what the estate is, you don't always need an attorney. Like for example, if you're married and everything is joint, um, then you probably don't even need to probate the will
Okay.
if the intent is for everything to go to your spouse. Um, you can do it anyway, or there are documents. They're probably different in each state, but there's like a tax document you can fill out that you're the beneficiary. You would just need to produce a copy of the death certificate. to show that they've passed. And then you'd fill out this tax document, and that would turn, the joint bank account from, both of your names just into the surviving spouse's name. If it's simple, you also could probate the estate yourself. In New Jersey, probate is really simple. Um, so you could take that death certificate and the original will and go to your county surrogate, and they would help you probate the document, and you could manage it yourself, right? If you've only got maybe like a car and a bank account, you probably don't need an attorney. But if you're not sure, it definitely would make sense to call one. A lot of attorneys will give you a half an hour free
Mm.
consultation just to kind of figure out uh, whether or not you really need an attorney. And if not, they'll give you a little bit of advice on what to do. If not, that attorney will help you probate the will and go through the next steps, and they'll walk you through whatever is common where you live, whatever is necessary. Um,
Can you what is probate? Just so people know,
so
and
yeah,
me.
probate is you take the will to the court and they file it. Um, that's probating the will, and then probate is
Okay.
the process of distributing, that's part of the process of distributing the estate.
Okay. So if I'm the executor and I grab the will of the person who's died, I don't necessarily need to go see the same attorney who created the will, right? I can go
No.
see my own attorney.
Yeah, absolutely.
Okay.
You could get, yes. And this is some, actually, it's, I'm glad that you mentioned that, because some attorneys who do wills will insist that they need to hold the original in their safe in their office
Mm.
for exactly that reason. They want to get the business when you die. So they try and sort of guilt people into using them, which is not ethical or proper. You, as the executor, can pick whatever attorney you want to help you, whoever you're comfortable with. It does not need to be the person that created the will.
Okay.
The only advantage, maybe, of using the person who created the will is that if you have any questions, right, they should have notes in their file about all of the conversations that were had in drafting the will. So they might have more context for decisions that were made, just what the thought process was, which sometimes is helpful.
Mhm.
Um, but if you don't like them, if you don't trust them, or maybe you just have somebody that you're more comfortable with, there's no reason to not use the person that you prefer.
Okay. In the movies,
Mhm.
sometimes you'll see these scenes where somebody dies and then the family goes to this big fancy room and somebody reads the will and everybody finds out what they get. Is that
Yeah.
real? Does that happen?
I mean, maybe some people do that. I don't personally know of any time that's happened. Um, Again, most people already know what's going to be in the will, or they're not surprised by what's in it, right? The conversations have been had during that person's life about what they want. Um, I imagine maybe for very, very, very wealthy people, that's a thing
Mhm.
that's done. But I don't know of anyone in real life who's ever done that.
Okay.
I don't think it's really a real thing anymore.
Okay. Okay. Um, and then what happens, like, if people disagree about what's in the will?
So if they disagree with it or they don't like it, they can contest it, um, which they'd have to bring an action in court, and they would have to be able to prove that um, the person was not competent to make the will at the time, which is going
Okay.
to be very challenging to prove. Right. You can disagree with it. It doesn't, right. Maybe you think, well, I'm also their child and I should have gotten my share. Just because you're their child, at least in New Jersey, you're not required to give, they're not entitled to a share of your estate if you choose not to give them something. If you disagree with it, you could sue and contest the will. Usually, um, that will be settled. It's very rare that it'll get to the point where the court decides,
Okay.
just because it's pretty expensive to do that, and it takes a really long time. And usually people will just try and work it out amongst themselves.
That's the end of my questions.
Okay.
But I just want to ask you if there's,
Yeah.
I know we didn't cover everything, but we did cover a lot. So is there anything that you feel like we didn't talk about that should be brought up, or anything on the topic that people should know?
I think we did a pretty good overview of stuff. I mean, I think anything else would be very specific to a person.
Okay, thank you
Um,
so much for doing this.
yeah,
I think it was,
absolutely.
I definitely learned a lot, and I hope other people do too. So I appreciate it.
I think it shouldn't be so overwhelming. So I hope that that helps people feel less overwhelmed.
Yes,
Yeah.
that's what the whole goal of this is for everything.
Yeah.
So yeah.